Good morning and welcome to the 30th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have no apologies this morning. Our first and only agenda item today is the consideration of the Children Withdrawal from Religious Education and Amendment of UNCRC Compatibility Duty Scotland Bill at Stage 2. I will briefly explain the procedure we will be following during today's proceedings for anyone watching. Members should have with them a copy of the bill, the marshalled list and the groupings. These documents are available on the bill webpage on the Scottish Parliament's website for anyone observing. I will call each amendment individually in the order of the marshalled list. The member who lodged the amendment should either move it or say not moved when it is called. If that member doesn't move it or any other member present may do so. The groupings of amendments set out the amendments in the order in which they will be debated. There will be one debate on each group of amendments. In each debate, I will call the member who lodged the first amendment in the group to speak to and move that amendment and to speak to all other amendments in that group. I will then call other members with amendments in the group to speak to, but not to move their amendments, and to speak to other amendments in the group if they wish. I will then call any other member who wishes to speak in the debate. Members wishing to speak should indicate that by catching myself or the clerk's attention. I will then call the Cabinet Secretary if she has not already spoken in the debate. Finally, I will call the member who moved the first amendment in the group to wind up and to indicate whether he or she wishes to press the amendment or to withdraw it. If the amendment is pressed, I will put the question on the amendment. If a member wishes to withdraw an amendment after it has been moved and debated, I will ask whether any member present objects. If there is an objection, I will immediately put the question on the amendment. Later amendments in the group are not debated again when they are reached. If they are moved, I will put the question on them straight away. If there is a division, only committee members are entitled to vote. Voting is by a show of hands, and it's important that members keep their hands raised clearly until the clerk has recorded their names. If there is a tie, I must exercise a casting vote. The committee is also required to consider and decide on each section and schedule of the bill and the long title. I will put the question on each of these provisions at the appropriate point. I should note that the aim today is to complete consideration of the bill at stage 2. We will now move on to the process. I call Amendment 9 in the name of Maggie Chapman, grouped with amendments as shown in the groupings.
Good morning, everyone. Thank you, Convener, and good morning to the Minister and officials. Thank you for being here this morning, and thank you for the conversations we've had about this bill in recent months. Before I turn to my amendments, I want to briefly outline the Scottish Greens' approach to this bill as a whole. Last year, we enshrined the UN Convention on the Rights of the Child into Scots law. Doing that was not the end of a process of protecting the rights of children and young people, but the start. We have committed that every service we provide for a child or young person, from school to social security, from care to children's hearing system, should put their rights, those children's rights, in the UN Convention front and centre. And where we have failed to do that, children and young people should be empowered to speak up and call for change, and we as policymakers should have to respond. The bill before us today reflects what the Together, the Alliance for Children's Rights, the Children and Young People's Commissioner and others have been saying about the Scottish Government's approach to children and young people's rights more generally. Namely, that it comes from a place of the best of intentions, but it does not go nearly far enough. It is fundamental to the Convention that the rights of children and young people should exist independent of those of adults. Yet the bill allows for children to opt out of religious activities in schools only once their parent or guardian has already made a decision. Part 2 of the bill creates a framework for adults to override the Convention only a year after it came into force. If we are truly going to enshrine the Convention not only into law, but into the everyday practice of the services children and young people receive, we need to look again at quite large parts of this bill. I'll turn now to the amendments in this group. The principal amendment of mine is Amendment 9, and I move that amendment in my name. The other amendments are consequential to that. Like the original 1980 Education Act, the bill conflates religious observance with religious education. Religious observance are acts of worship, especially when one faith is prioritised over another. These should have no place in state schools. The Scottish Green position is quite clear. There should be separation of church and state.
Will the member take an intervention?
Yes.
I'm very grateful to Maggie Chapman for taking the intervention so early in her contribution. I recognise what she's saying in terms of her view and the view of the Scottish Green Party on the separation of church and state. And does that extend to denominational provision in Scotland? Because obviously, due to the 1918 Act, we have a almost unique in some ways situation in Scotland through what we would recognise probably as a social contract. Is it her view that there shouldn't be denominational provision? Because I think if we're going to decouple things, we have to look at both spheres of non-denominational and denominational education.
Paul O'Kane for his intervention, and in many ways we accept that the situation we have in Scotland is, as you outline, if not unique, almost unique in having those denominational positions. Whilst those denominational schools exist, we need to have very, very clear mechanisms for ensuring that children and young people's rights are protected regardless of where they go to school. It is a principal position of the Scottish Greens that we would have total separation of church and state. So the Education Act, 1980 Act, conflates religious observance with religious education, also called religious instruction. Religious observance are those acts of worship when one faith is prioritised. Religious and moral education, or RME, is quite different. Learning about diverse religions and belief systems is an essential part of a broad education in a diverse society. Children and young people have a right to a well-rounded education, and their parent or guardian should not be able to override that. Young people cannot withdraw or be withdrawn from maths, science, history, English. That is for good reason. These provide key knowledge bases and skills they need to be the successful learner, confident individual and responsible citizen, as well as being an effective contributor to the curriculum for excellence wants them to be in society. Religious and moral education is similarly vital in our view, and teachers agree. Dr. Douglas Hutchison of the Association of Directors of Education has said, and I quote, "Religious and moral education should be seen as a curricular subject in the same way as any other subject." He continued, "The idea that in a liberal democracy there is no place in the curriculum for religious education and there should be a right to withdraw from it does not make sense in 2025. I'm aware of the Children and Young People's Commissioner their queries over some of the wordings in these amendments, particularly that word instruction. They refer to General Comment 20 from the UN Committee on the Rights of the Child, which distinguishes between religious education and religious instruction, and that there should be the right to withdraw from the latter, not the former. The wording was worked up with the Scottish Government, and I'm grateful to the Government for collaborative working on this. But ultimately that wording reflects the 1980 Act, that original language, and as a consequence of the bill's approach of amending that language rather than re-legislating, which is an alternative approach outlined by the Commissioner. I do share some of these concerns but would ask that the committee support the principle of these amendments and Amendment 9 and its consequentials, and I'll work with committee and others if we need to fix any wording for stage 3. Thank you. I'll leave it there.
Thank you. I draw members' attention to the procedural information in relation to these amendments as set out in the groupings. Tess White to move Amendment 9A and speak to all amendments in the group.
Thank you, Convener. I move Amendment 9A. Convener, Cabinet Secretary, Amendments 9A, 20 and 44 in the name of Stephen Kerr bring clarity and coherence to an area of education law that has become confused through age and custom. These amendments are grounded in what the committee heard at stage 1, where evidence repeatedly highlighted the need to distinguish clearly between religious observance and religious and moral education. That distinction is well understood in practice but poorly reflected in the legislation that governs it. Amendment 44 introduces statutory definitions of religious observance and of instruction in religious or religious subjects. These definitions reflect the reality of curriculum for excellence and the experience of our schools. Religious observance refers to reflective or spiritual activities. Religious and moral education refers to curricular learning about belief systems, world religions, and moral reasoning. Bringing these definitions into statute is not an attempt to change the curriculum, it's simply an attempt to ensure that the law accurately reflects what teachers already deliver. Amendment 20 works hand in hand with that clarification. It ensures that requests for withdrawal from religious observance and requests for withdrawal from religious and moral education are treated as distinct processes. In the evidence sessions, this point was raised by several contributors who noted that the bill, as drafted, risks conflating the two areas, and that's something that has already been addressed. The amendment protects the curricular entitlement that every pupil in Scotland has to both religious and moral education, while preserving the long-standing right of withdrawal from religious observance. It restores coherence and presents misunderstandings in implementation. Amendment 9A adds a further technical clarification by confirming that instruction in religion includes denominational religious education, and this avoids any confusion about how the bill interacts with the existing denominational school settlement and provides reassurance to parents and communities who rely on those long-established statutory rights. Convener, Cabinet Secretary and Committee, these amendments do not challenge the intentions of the bill. They strengthen it by removing ambiguity and setting out in clear terms what the law means. They are principled in their purpose, they respect the vital role of parents, they protect the integrity of the curriculum, and they offer reassurance to teachers and to faith communities that the terminology used in the statute aligns with what actually happens in schools.
Thank you very much, Convener. I would thank colleagues for their amendments in this group and for allowing us to have a wider debate on the scope of withdrawal rights and whether that should indeed apply to religious education or not. I don't think there is an issue in the bill that perhaps represents better the complexity of the issues that have been brought up in the process. And I do have to say that I think it's frustrating that we're now having this debate at stage 2 at a point in the Parliament where we only have 3 months of legislative time left, rather than perhaps working through the details in a broader sense. I would recognise, as many colleagues I'm sure do, the frustration of many religious, moral and philosophical studies teachers at the idea that their discipline and their academic subject is somehow unique and is acceptable to being withdrawn from in comparison to other subjects taught in schools, because they are, of course, subject professionals. They're educating our children and young people with vital knowledge about religious and belief systems and the encounters those young people will have with those in the wider world, whilst equipping them with skills to interrogate different moral systems and belief systems. But I think that is true in a non-denominational school setting. And my concern, my significant concern around these amendments are that we don't appear to be taking cognizance of the different religious education that is offered in denominational settings. Predominantly in Scotland, that's in the Roman Catholic sector, but of course in the Jewish and Episcopalian sector as well. So I will, certainly.
I'm grateful to Paul O'Kane for taking my intervention. I appreciate your comments about that frustration that we're talking about this now. I think that was expressed very, very clearly in the stage 1 evidence gathering that committee did. In that evidence gathering, it was quite clear that even representatives from the denominational schools that you've just mentioned support the separation. And I think there is frustration that that broader education and instruction, as the 1980 Act calls it, is conflated with essentially worship, and that those two things remain and should be distinct. And denominational schools, denominational leaders and teachers were comfortable with that. Some of them said, you know, there is that distinction, and we can make that work. And I'd just be interested in your response to that.
I thank Maggie Chapman for that intervention. I'll certainly revisit the evidence that was taken, as I wasn't on the committee at the time. But certainly understandings from my conversations around these amendments and around the stage 2 process is that there is concern in the denominational sector about how do you separate RE and RO in a Catholic school, for example, when the two things are interconnected. And I think there's 2 points to this, which I was coming on to express. One is RE in a Catholic school by its nature is Catholic. So whilst there will be the study of other religions and moral systems, there will be a Catholicity to what is taught in RE. RO in a Catholic school permeates the entire ethos of the school. So it is not, as it is in the non-denominational sector, where there will be set times for RO at periods in the year. In a Catholic school, there will be opportunities throughout the day in order to observe the Catholic religion within the school, which is true actually of the Jewish school in East Renfrewshire as well, because culturally that will permeate the day in terms of prayer and things like that as well. So I think it is hard to sort of decouple RO and RE in that setting. And I think there's 2 things in that. One, I think many people in the denominational sector are concerned that we're taking I suppose a secular view of RO and a view of RO as it would exist in a non-denominational setting, and not looking at it in terms of its interconnectedness in the denominational setting. So I think there's a concern about the value of both RE and RO in that setting, and this is the unique, as I said, placing of that within those schools. But I think if we flip that on its head as well, I do have a slight concern that parents being unable to withdraw from RE in a Catholic school in particular actually is probably more problematic than we might have first considered, because if you want to remove your child from a very specific RE, which is Roman Catholic, then you will not be able to do that. It's more difficult to remove your child from RO in a Catholic school because, as I say, it permeates the life of the school. So I do think that I have a concern here just about parental rights in that space, but I do have a wider concern about we're not talking necessarily about exactly the same thing in terms of RMPS in a non-denominational school and RE in a denominational school. So again, I think I referred to the complexities, and I think that's true of this bill and of this amendment in particular. It is a long-standing piece of statute in this country that we have denominational schools, and in particular that we have Catholic schools. It is my party's position and the position I continue to hold that I support that long-standing definition. And I think, however, it is wrong to assume that only pupils and families of particular denominations choose and attend denominational schools. And I think we probably all would recognise that from our regions, that those schools are attended by a variety of young people for a variety of reasons. So again, I would just reiterate that point about ensuring that we're taking a very careful and considered approach to how this amendment would work in the denominational sector. And I have raised these issues with the Cabinet Secretary, and I understand from Ms Chapman's comments that the Government are intending to support this amendment today. I would perhaps caution that it is possibly not the right time to support an amendment without understanding exactly how that's going to impact on denominational education more widely. And rather than having to try and fix something at stage 3, I would much rather we took our time and had a considered approach to this, which we can then obviously revisit at stage 3 as well. And I think more widely, because of many of the complexities I've referenced, I can't support the amendments in the name of Maggie Chapman or of Stephen Kerr in the group. I think I've outlined those reasons and would welcome further contributions to understand the position. Thank you, Convener.
Okay, thank you. Cabinet Secretary.
Convener, the Group 1 amendments, as we've heard, relate to the scope of rights concerning the withdrawal of pupils from religious observance and/or religious and moral education. I will therefore speak to them as a group. The amendments in the name of Maggie Chapman, as we have heard, amendments 9 through to 17 and 19, would separate religious observance and religious and moral education, or RME as it's known. This would mean that the parental right to withdraw applies to religious observance only. Should these amendments be agreed, it will no longer be possible to withdraw a child from RME. These amendments give effect to the committee's recommendation in its Stage 1 report that religious observance and RME should be separated, so that the ability to withdraw only applies to religious observance. The committee made clear its recognition of the benefits of RME for community cohesion, particularly in the current times, and its importance as a core curriculum area. And this view has also been echoed by a number of stakeholders, as we've heard this morning, including the Scottish Teachers Association of RME, and representatives of various faith and belief groups, including the Humanist Society Scotland. I agree with the committee and these stakeholders. As well as being a valuable academic discipline in itself, RME supports and enables children and young people to learn about and from different religions and worldviews, as well as to explore ethical questions. Contemporary RME is very different from the religious instruction of the past and in the context of the 1870s, when the parental right to withdraw was first introduced. So RME today is one of the core 8 curriculum areas, and it's delivered in a manner which is objective, critical and pluralistic. These amendments would also remove the oddity of RME being the only curriculum area with an associated legal withdrawal right. I do, however, recognise the continuing need to provide non-statutory guidance and curriculum frameworks to safeguard the integrity of the subject. And I will, of course, also be thoughtful about ensuring those changes work in practice for denominational schools, as we have heard, which rightly have specific legal protections in relation to their faith character. And as we've heard from Mr O'Kane, happy to give way.
I'm grateful to the Cabinet Secretary just on that point. And I would be keen to understand if she's had any thought about how that might happen. She will know through her time as Cabinet Secretary and her own career that the E's and O's, obviously, in RERC are different and distinct, and talk about, I suppose, that connection between observing your faith and learning about it, and learning about it in the context of the world and of other faiths. So I'm just keen to understand what work she has done or is planning to do on that.
I thank Mr O'Kane for his intervention. Obviously, following our discussion, I discussed this matter in detail with officials. They've started engagement already with the Scottish Catholic Education Service to give Mr O'Kane some reassurance, but we also want to engage ahead of Stage 3 around about how this will work in relation to the points he raises in terms of denominational schools. I'm also mindful, though, of my own engagement with SCES on this issue, in which they pointed out we are talking about extremely small numbers of pupils in a Catholic education setting because, of course, parents have chosen to send their children to that school often for faith-based reasons. So we're talking about a very small number of pupils. However, we do not think it's insurmountable that we'll be able to address these issues at Stage 3. I hear the concerns the member has raised, but I hope he does take some reassurance that we are already having those engagements with the Scottish Catholic Education Service. But I am very mindful of the committee's report at Stage 1, which did recommend that we took this issue away and look to clarify the differences between RO and RME, and that's what we have sought to provide for. So I therefore support Maggie Chapman's amendments, and I would encourage members to do the same. Now, Stephen Kerr's Amendment 9A would explicitly state that the section inserted by Amendment 9 applies to religious education in denominational schools as well as non-denominational schools. I do not think that amendment is necessary because those provisions in the bill already apply to both denominational and non-denominational schools. But moreover, there is a risk that Amendment 9A would create confusion regarding whether or not other provisions in the bill and relevant sections of the 1980 Act apply generally to denominational schools, which they do. I would therefore hope that Stephen Kerr might not press this amendment, or rather I should say test white on his behalf. Amendment 20 would require separate treatment of parental requests, as we have heard, to withdraw a pupil from religious observance and RME respectively. Again, I do not consider that amendment to be necessary. If Maggie Chapman's amendments are agreed to, then part of that amendment is in effect obsolete. So given that the right to withdraw from RME would be removed. But it is worth pointing out that schools already make the differences between religious observance and RME clear to parents in discussions about withdrawal, and withdrawals are not always made from both. The legal requirement that exists to consider requests separately might result in additional burdens on schools, pupils and parents, for example, by requiring additional paperwork. So I would therefore encourage members to resist Amendment 20. Finally, in relation to Amendment 44, this provides the legal definitions of religious observance and RME referred to in the 1980 Act, and therefore in this amendment as instruction in religion. As I have already said, I recognise the importance of drawing a clear distinction between RO and RME. Providing those definitions in legislation would reduce future flexibility for course content to evolve over time, as it does. And it is worth remembering that the provisions in the bill originate from the 19th century, and the curriculum has evolved in multiple ways since that time, even since the passing of the 1980 Act. Furthermore, definitions of religious observance and RME are already provided for in the non-statutory guidance. Those definitions differ from the definitions listed in Mr Kerr's amendments, and as they reflect government policy, are preferable. Amendment 44 is therefore unnecessary and likely to create confusion, and I'm not able to support it today. Convener, in summary, I would encourage members to vote for Amendments 9, 10, 11, 12, 13, 14, 15, 16, 17 and 19, and I would hope that Tess White, on behalf of Stephen Kerr, will not press Amendments 9A, 20 and 44.
Maggie Chapman to wind up on Amendment 9.
Thank you very much, Convener, and I thank the Cabinet Secretary for her comments. I'm sympathetic, just on Stephen Kerr's amendments, I'm sympathetic to some of the intention in them, but like the Cabinet Secretary, I don't think the first two in this group are necessary. And Amendment 44, with those definitions, I share the Cabinet Secretary's concerns about constraining definitions, and also that what are listed in those two definitions, I think, are too prescriptive, and I think we can maybe have ongoing conversations between now and stage 3 to see where we get to in the space, if we can come to an agreement. Just to wrap up on my amendments, these amendments fulfil the committee's recommendation to separate religious observance and RME, focusing the existing parental right to withdraw on RO, no longer allowing parents to withdraw their child from RME as a curriculum area, recognising the value of RME as objective, critical and pluralistic, and important to supporting young people to learn about and from different faiths, beliefs and worldview. So for these reasons, and for the wealth of evidence we heard in the space during our stage 1 evidence gathering, I would urge committee colleagues to support the amendments in my name in this group. Thank you.
Tess White to wind up, press or withdraw Amendment 9A.
Thank you, Convener. I think what's just happened now in this first group shows that there are some fundamental issues which should have been ironed out before we got to this stage. So we're talking about some issues with the faith schools, and Cabinet Secretary, you might say it's only a small number, but it's a very significant number, and those discussions should have taken place before now. This bill, as was described to us, is a very small bill. I think it's 5 pages, but it has huge and wide-ranging ramifications. The amendments were put forward by Stephen Kerr to try and clarify and give some definitions, so I would like to press the 3 amendments, please. Thank you.
Thank you. The question is that Amendment 9A be agreed to. Are we all agreed? No. Okay, we are not agreed. There will be a division. Those in favour of Amendment 9A? Those against? Any abstentions? The result on the division of Amendment 9A is 2 for, 5 against. The amendment is therefore disagreed to. Maggie Chapman to press or withdraw Amendment 9.
Press.
The question is that Amendment 9 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 9? Those against? Any abstentions? The result of the division on Amendment 9 is 4 for, 3 against. The amendment is therefore agreed to. I call Amendments 10, 11, 12, 13 and 14, all in the name of Maggie Chapman and all previously debated with Amendment 9. I invite Maggie Chapman to move Amendments 10 to 14 en bloc.
Moved on block.
Does any member object to a single question being put on Amendments 10 to 14? No. The question is that Amendments 10 to 14 are agreed to. Are we all agreed?
No.
Okay. Okay. Thank you. So we are not agreed and there will be a division. Those in favour? Apologies. Okay, we have not agreed to move them en bloc. Okay. So I will be calling Amendment 10 in the name of Maggie Chapman, previously debated with Amendment 9. Thank you. So the question is that Amendment 10 is agreed to. Are we all agreed? Yes. Okay. We are not agreed. There will be a division. Those in favour of Amendment 10? Paul, pay attention. Stop paying attention. Okay, those against? Okay, any abstentions? No. The result of the division on Amendment 10 is 4 for, 3 against and no abstentions. The amendment is therefore agreed to. I call Amendment 11. Yeah, previously debated with Amendment 9. The question is that Amendment 11 is agreed to. Are we all agreed? Yes. We are not agreed. There will be a division. Those in favour of Amendment 11? Those against? Any abstentions? The result on the division of Amendment 11 is 4 for, 3 against and no abstentions. The amendment is therefore agreed to. I call Amendment 12, previously debated with Amendment 9. The question is that Amendment 12 be agreed to. Are we all agreed? Yes. No. We are not agreed. There will be a division. Those in favour of Amendment 12? Those against? Any abstentions? The result of the division on Amendment 12 is 4 for, 3 against and no abstentions. The amendment is therefore agreed to. I call Amendment 13, previously debated with Amendment 9. The question is that Amendment 13 is agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 13? Those against? And any abstentions? The result of the division on Amendment 13 is 4 for, 3 against, no abstentions. The amendment is therefore agreed to. I call Amendment 14, previously debated with Amendment 9. The question is that Amendment 14 is agreed to. Are we all agreed? Yes. No. We are not agreed. There will be a division. Those in favour of Amendment 14? Those against? Any abstentions? The result on Amendment 14 is 4 for, 3 against and no abstentions. The amendment is therefore agreed to. I now call Amendment 20 in the name of Stephen Kerr, already debated with Amendment 9. Tess White to move or not to move.
I move.
The question is that Amendment 20 be agreed to. Are we all agreed? Yes. We are not agreed. There will be a division. Those in favour of Amendment 20? Those against? Any abstentions? The result of the division on Amendment 20 is 2 for, 5 against and no abstentions. The amendment is therefore disagreed to. I now call Amendment 21 in the name of Tess White, grouped with amendments as shown in the groupings. I draw members' attention to the procedural information in relation to these amendments as set out in the groupings. Tess White to move Amendment 21 and speak to all amendments in the group.
Move to convener. Convener, Committee, Cabinet Secretary. These amendments are about making sure the process that follows a withdrawal request is clear, fair and workable for families and schools. At stage 1, we heard very strong concerns that the bill as drafted places schools in the middle of a sensitive, very, very sensitive family decisions without enough clarity or support, and this group of amendments responds directly to that evidence. Amendment 21 requires schools to provide parents with written information setting out the steps that will be followed once a withdrawal request is made. At the moment, parents may not know what will happen next or how decisions will be taken. This amendment brings clarity from the start and helps manage expectations. Amendment 22 ensures that where possible, all those with parental rights and responsibilities are informed and involved in the process. This is particularly important in cases of separation or shared care, and it helps avoid situations where one parent is excluded from decisions about their child without good reason. Amendments 23 and 24 make clearer what schools must actively consider by requiring them to take account of the child's circumstances and the likely impact of the request on the child's emotional well-being. And this helps ensure that the decisions are thoughtful and child-centred rather than a simple tick-box exercise, and it aims to stop that. Amendments 26 and 27 deal with the issue of capacity. As drafted, the bill assumes that children of any age are capable of forming a view unless proven otherwise. These amendments introduce a presumption that children under 16 don't have the maturity to form a view, and that a pupil aged 16 and over does, unless the contrary is shown.
On that point, I'm interested in what Tess White is saying about capacity and the presumption against expecting or understanding capacity if a young person is under the age of 16. How does she consider that aligns with the principles as set out in the UNCRC and elsewhere across legislation that we've already passed in this Parliament that assumes capacity unless there are reasons not to? So there's a presumption for, rather than as this amendment would do, put in a presumption against. I just wonder how you see that aligns with our current existing legal and other practices.
Yes, okay. So there was evidence that we got from the legal profession that basically said the law is all over the place regarding age. You know, in the justice system, in certain cases it's 25, in other cases, in Scotland it's 18, majority of cases it's 16. And the Greens and the Conservatives are a fundamental disagreement that we believe that in this case the parents have the right and the responsibility, and I just refer everybody to the parental responsibilities of the Children's Scotland Act 1995, and a parent has in relation to the child the responsibility to safeguard and promote child's health, development and welfare, to provide in a manner appropriate to the stage of development of the child, direction and guidance. And there's a reason for that. And that's why in my amendments I'm proposing, and I will continue, because we are a fundamental disagreement, and it's about the age of maturity, and frameworks have to be set, otherwise it's chaos. And it's not fair for the children, for the teachers who are not qualified or trained in this to make a decision about maturity. It's not fair on them when the parents have the responsibility to decide on the guidance and what's right for their child. No, I think I've answered the question. I am going to proceed. So amendments 26 and 27 deal with the issue of capacity, as we've just discussed. As drafted, the bill assumes that children of any age are capable of forming a view unless proven otherwise, and that's something we've just discussed. And the amendments introduce a presumption that children under 16 don't have the maturity to form a view. And I've said that again because that's our position. And I use the age of 16 because, as I've said, it is a well-established point in Scots law when young people gain an increased level of autonomy. And below that age, parents remain legally responsible for the child's upbringing and welfare, and that needs to be properly reflected in the process. You can't sort of decide for one it's this and for another it's something else. And a key point is that it doesn't silence young children. Young children do need to be respected and their voices heard. But what it does do, it simply recognises that age and maturity matter, and that schools shouldn't be left making open-ended judgments without a clear framework. Amendments 28, 29 and 30 change when decisions can take effect by preventing a withdrawal request from being acted on until the full process set out in the bill has been completed. And it avoids a rushed decision. It sort of presses pause, that particularly where there's a disagreement between a child and their parent. Amendment 31 introduces a requirement for written confirmation from both the parent and the pupil setting out their respective positions, and this is for the sake of good order. This provides clarity about each person's view, avoids misunderstandings, and gives schools a clear record of the decision-making process. Amendment 32 introduces a mandatory 14-day cooling-off period before any withdrawal or change in withdrawal can take effect, during which any further views expressed by the child must be considered. This allows time for reflection and helps ensure decisions aren't made in haste. Amendment 33 requires key decisions to be taken by a panel made up of senior education staff and an independent advocate rather than by a single individual. That brings balance, experience and independence and reduces pressure on teachers. And finally, Amendment 42 ensures that advice and assistance are available to both the child and the parent if agreement can't be reached after discussion. And this is about support and fairness, not about escalation and conflict. Thank you.
Pam Gossall to speak to Amendment 5 and other amendments in the group.
Thank you, Convener. I move both amendments in my name, 5 and 6. The bill currently presumes that every child, regardless of the age, is capable of forming a view unless proven otherwise. At stage 1, many parents and education professionals raised concerns that this places an unreasonable pressure on younger children and leaves teachers making difficult judgments about capacity without a clear framework. As drafted, the bill risks creating conflict between pupils and parents and placing schools in a very difficult position. Amendment 5 removes the automatic presumption and replaces it with a more realistic test. It requires schools to be satisfied that a pupil can meaningfully express a view, taking account of their age, stage of development and understanding. This reduces risk for schools, supports teachers and still ensures the children's views are taken seriously where appropriate. Amendment 6 addresses a concern with the bill as drafted, which is that a pupil's objection would normally determine the outcome of parental requests to withdraw. As this committee has recognised, parents are the primary guardians of their children and have legal responsibility for their upbringing and education, this amendment doesn't remove the pupil's voice. It requires schools to take account of the pupil's views, but makes it clear that the parent's request should be given effect unless the school is satisfied, having regard to those views, that doing so would be contrary to the pupil's best interest. That is a balanced and proportionate approach. It protects children where there is a genuine welfare concern, while avoiding a situation where schools are routinely placed in conflict with parents over sensitive family decisions.
Okay. Paul O'Kane.
Thank you, Convener. I don't want to detain committee too much by speaking to all the amendments in the group, but I do want to briefly speak to the general issues that are raised by amendments 31, 32, 33 and the others in the group on the operability of how changes being proposed in the bill might work in practice. I think the Scottish Government has not thus far provided sufficient clarity on how the process of any pupil objection to withdrawal should be handled by schools in practice. I think particularly given the risk of creating intra-family conflict and tension between pupils and parents who would perhaps take a distinct view on whether to participate in religious observance or education, I think the bill does put schools and teachers in the middle of that conflict. And we are going to have yes, of course.
I thank Mr O'Kane for giving way. I think the committee has heard previous evidence that there already exists conflict at the current time in relation to how the right to withdrawal operates. So conflict already exists. I'm not necessarily sure I follow that this will lead to further conflict in that regard. And in addition to that, of course, at stage one, I set out our approach will be to provide clarity in relation to the guidance here on the issues that Mr O'Kane has raised.
Well, I'm grateful to the Cabinet Secretary for that intervention, mainly because my next sentence was literally we need strong and robust guidance and directives on how process can be managed. I would just say to her, though, I do think where we formalise a process, I do think that can give rise to conflict that is I think when you get into a process, in particular a process that feels legalistic, I do think you can have a certain degree of more formalised conflict, perhaps. So I appreciate the Cabinet Secretary's cognizant of that, and I think it's useful to hear her assurance on guidance, because teachers in our schools in no small part rely on trust and the relationship of trust between pupils, parents and school staff in order to carry out fully the functions of what we would all expect to be happening in our schools. I think that pushing teachers perhaps to make determinations about capacity, for example, can often intensify the issue that is often very personal to families and indeed personal to someone's own religious beliefs and religious feelings and their sense of perhaps being on a journey around some of that. So I do think we just need to be really cognizant of the challenges therein. I think it also raises one of the issues with Amendment 24, which would require operators to give consideration to pupils' well-being. I think, again, as with many amendments in the bill, there is good intention behind much of this. But perhaps, given what we've just discussed on conflict, I do think we just need to be careful about legislating for things that are require a degree of nuance and a degree of conversation and dialogue within school. Because I remain unclear exactly how we would define that well-being sort of test and how we would, how we would actually understand the measure that would be taken in that space. So I would contend that there's much in this that needs to be dealt with in guidance and that it will hopefully empower teachers and schools to feel confident in what it is they're being asked to do. I'm not clear at this stage the right versions to provide some of that clarity and support are there, but as I've said, I do hope that is something we will further discuss in the approach to stage 3 and, of course, if necessary, by amendment at stage 3. And having said I wasn't going to speak for very long, I actually did, so apologies, Convener, and thank you.
Thank you. Cabinet Secretary.
Convener, amendments in Group 2 speak to the need for a balance to be struck between the need to ensure that there is a sufficiently robust process in place and also the need to avoid imposing undue burdens on parents and pupils and on schools. Amendment 21, in the name of Tess White, as we have heard, would require schools to provide parents with written information about how the withdrawal process will be handled. This is a proportionate and a practical measure. While schools are already required to include this information in handbooks, anecdotal evidence suggests that parents are often not aware of their right to withdraw their child from RO or RME. So providing that written guidance when a withdrawal request is made would help parents to understand their rights. Potentially, it would also help to reduce disputes. It would not introduce significant costs or complexity, as it could be a standard form included in and supported by the guidance that's been mentioned already accompanying the bill. I'm therefore happy to support Amendment 21. Amendment 22 would require operators to notify all persons with parental rights and responsibilities when informing the pupil about a withdrawal request. This amendment is unnecessary and unhelpful, as the language used is not consistent with the 1980 Act, which already provides a broad definition of parent, which includes guardians and others with parental responsibilities, including a different and a narrower definition, risk confusion and inconsistency. The duty in Amendment 22 would also apply regardless of family circumstances, which means that unnecessary notifications would be made where both parents live together. In other circumstances, including where parents are separated and there is conflict about the child's upbringing, the school's operator would be required to notify the other parent, regardless of any relevant agreements or court orders relating to the child's upbringing. I would hope that members might see how unhelpful such a provision in the bill could be. Now, Amendments 23 and 24 would add a requirement to consider the pupil's emotional well-being when having regard to their views. While that is a very important consideration, those amendments would introduce subjective and undefined criteria at odds with the existing duties which are covered by the wellbeing principles under GIRFEC to ensure pupils' welfare. Adding that requirement is therefore unnecessary. Amendment 25 seeks to prevent operators from expressing or implying a view about whether or not a pupil should object to withdrawal. Now, teachers are already bound by professional standards to act with integrity and to avoid bias. So this amendment is both unnecessary and it also could undermine respect for teachers' professionalism. I mentioned in my Stage 1 evidence that guidance will accompany this bill. I mentioned it already today. I would suggest that this guidance could usefully reinforce the importance of objectivity without suggesting that teachers would act counter to their professional standards. And I would hope that that reassures the member on behalf of Mr Kerr and that Amendment 25 will subsequently not be pressed. Now, in relation to Pam Gossel's Amendment 5, that would replace, as we have heard, the presumption that a pupil is capable of forming a view unless the contrary is shown, with a test requiring the operator to judge whether the pupil can meaningfully express a view on the request, having regard to their age, stage of development and understanding. This wording is quite unclear and it introduces a higher assessment threshold and greater complexity for schools, which could encourage inconsistency across schools. Amendment 6, which I tried to intervene on earlier on, seeks to replace the current bill provision where a pupil's objection prevents withdrawal with a best interest test. That creates another additional barrier to the pupil's decision being respected. This would mean that where a pupil objects, their decision would only be respected if the operator judged their withdrawal to be contrary to their best interests. This new test would also seem to create further complexity for schools, would risk inconsistency and increase workload in terms of mediating between pupil and parent, and we've already heard some of the challenges associated there from Mr O'Kane. Now, Amendments 26 and 27 seek to introduce a presumption of capacity at 16 and a presumption of incapacity below 16 for the pupil's right to have their views considered. This does not align with the UNCRC and recent domestic legislative precedents, and it's far removed from the capacity-based approach in the bill, which was supported by a majority of committee members, and I think Ms Chapman made a point on that in her intervention earlier. It would also exclude the vast majority of school-age pupils given the presumption of incapacity below 16. Amendments 31, 32 and 33 would introduce significant administrative complexity. Amendment 31 requires written confirmation from both parent and pupil before withdrawal can proceed. Amendment 32 imposes a 14-day waiting period and provides that if the child expresses further views during the 14-day period, then these views must be treated in the same way as initially expressed views. Amendment 33 requires decisions to be made by a panel, including the Director of Education, head teacher and, as we have heard, an independent advocate. Those changes would create delays, introduce unnecessary barriers for parents and pupils, increase costs and add disproportionate burdens on schools and local authorities. Larger local authorities in particular might find that provision impossible to deliver. Amendments 28, 29 and 30 are technical consequential changes linked to Amendments 31, 32 and 33 to introduce new conditions and processes. As those substantive amendments are not supported by the Government, I would also urge members to resist those amendments. Amendment 34 provides that nothing in Section 9A affects the responsibility of parents for the upbringing of moral education and welfare of their children. This amendment seeks to make an unnecessary and inappropriate provision relating to parental responsibilities, and it restates a principle that is already well established in Scots law. There is also a risk that the inclusion of this provision may imply that Section 1 cast doubt over the principle that parents have primary responsibility for their children's upbringing, which it does not. This amendment does not create new rights or duties and adds no substantive value to the Bill's provisions. Finally, Amendment 42 introduces a statutory obligation to provide legal aid for disputes between pupils and their parents about withdrawal from religious observance. This amendment would undermine the fact that schools and teachers are experienced in having complex and sensitive discussions with parents and pupils on a regular basis and already have well-established processes for resolving disagreements. But it would also have significant financial and administrative burdens, and it could create an expectation of formal legal involvement in discussions intended to be carried out at school level. So in summary, Convener, I would encourage members to support Amendment 21 and to vote against all other amendments in the group.
Thank you. Tess White, to wind up, press or withdraw Amendment 21.
Thank you, Cabinet Secretary, and thank you, Convener. In my summing up, I do want to address Stephen Kerr's amendments and just say a few words about those. I will address the point that Maggie Chapman raised. I want to address something that Pam Gossall said, and also the discussion and the question that the Cabinet Secretary had with Paul O'Kane. So if I start off with Stephen Kerr, so the aim of those two amendments was to provide clarity and to make sure there was fairness and balance. And they tried to introduce a requirement for neutrality, and they tried to ensure that the child's view is truly their own, not the product of subtle or unintended pressure from the school environment. And that was Amendment 25. Amendment 34, that provided an important reassurance in the wider context of family law, and it made sure it doesn't contradict anything in the bill, and it provided additional safeguards. In relation to Maggie Chapman's question, there is a balance, there's conflicts of rights here, and I did quote the Children's Scotland Act 1995, which the Cabinet Secretary will be familiar with and probably knows most of the paragraphs by heart. You can't take away the parents' responsibilities, and that's what this does, and that has massive, it drives a coach and horses through parental responsibilities. And I think, you know, one of the things that this bill doesn't do, it doesn't look at other legislation and cross-check and balance. And it's just my view, if the Cabinet Secretary and doesn't take account of issues like this, then conflict will arise, and it's bad lawmaking. In relation to Pam Gossall, Pam also talked at length about parental responsibility and leaving teachers and schools making really difficult decisions. And there does need to be a framework, and this bill lacks the framework. And finally, the question that the Cabinet Secretary raised with Paul O'Kane in relation to conflict, you said that conflict exists now. But part of the issue that came up as part of the Stage 1 inquiry was that there isn't sufficient data. The Scottish Government only looked at 3 schools. It made an estimate that there were 3 education authorities, didn't look at the whole of Scotland, just took a sample, and then estimated that there could be 4,000 cases. That's bad lawmaking, making a decision, a fundamental decision, and looking at the balance of rights between parents and child, and increasing burdens on schools is just bad lawmaking. So that was what I wanted to say about Paul O'Kane. And I know in the further grouping we will be discussing data and the importance data. So I will rest there, and I will move all the motions, the amendments in my name and Stephen Kerr's name. Thank you, Convener.
Okay. Thank you. The question is that Amendment 21 be agreed to. Are we all agreed? Yes, we're all agreed. I call Amendment 22 in the name of Tess White, already debated with Amendment 21. Tess White, to move or not move?
Moved, Convener.
Thank you. The question is that Amendment 22 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 22? Those against? Any abstentions? Thank you. The result of the division on Amendment 22 is 2-4, 5 against, no abstentions. The amendment is therefore disagreed to. I call Amendment 23 in the name of Tess White, already debated with Amendment 21. Tess White to move or not move?
Moved, convener.
The question is that Amendment 23 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 23? Those against? Any abstentions? The result of the division on Amendment 23 is 2-4, 5 against, no abstentions. The amendment is therefore disagreed to. I call Amendment 24 in the name of Tess White, already debated with Amendment 21. Tess White to move or not move?
Moved, convener.
The question is that Amendment 24 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 24? Those against? Any abstentions? The result of the division on Amendment 24 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 25 in the name of Stephen Kerr, already debated with Amendment 21. Tess White to move or not move?
Moved, convener.
The question is that Amendment 25 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 25? Those against? Any abstentions? The result of the division on Amendment 25 is 3-4, 4 against, no abstentions. The amendment is therefore disagreed to. The question is that Amendment 5 be agreed to. Are we all agreed? No. Oh, apologies. Apologies. I call Amendment 5 in the name of Pam Gossel, already debated with Amendment 21. Pam Gossel to move or not move?
I'm not convinced with the Cabinet Secretary's response in relation to having the right processes and framework in place. So on this occasion, I will be moving both amendments 5 and 6.
Thank you. The question is that Amendment 5 be agreed to. Are we all agreed? Yes. No. We are not agreed. There will be a division. Those in favour of Amendment 5? Those against? Any abstentions? The result of the division on Amendment 5 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 26 in the name of Tess White, already debated with Amendment 21. Tess White to move or not move?
Moved, convener.
The question is that Amendment 26 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 26? Those against? Any abstentions? The result of the division on Amendment 26 is 2-4, 5 against, no abstentions. The amendment is therefore disagreed to. I call Amendment 27 in the name of Tess White, already debated with Amendment 21. And I remind members that if Amendment 27 is agreed to, I cannot call Amendment 15 due to a preemption. Tess White to move or not move?
Moved, convener.
Thank you. The question is that Amendment 27 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 27? Those against? Any abstentions? The result of the division on Amendment 27 is 2 for, 4 against and 1 abstention. The amendment is therefore disagreed to. I call Amendment 15 in the name of Maggie Chapman, already debated with Amendment 9. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 15 be agreed to. Are we all agreed?
Yes.
Okay, we are not agreed. Those in favour of Amendment 15? Those against? Any abstentions? The result of the division on Amendment 15 is 4 for, 3 against. The amendment is therefore agreed. The question is... Apologies. Okay. I call Amendment 28 in the name of Tess White, already debated with Amendment 21. Tess White, to move or not to move?
Moved, convener.
Thank you. The question is that Amendment 28 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 28? Those against? Any abstentions? The result of the division on Amendment 28 is 2 for, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 29 in the name of Tess White, already debated with Amendment 21. Tess White, to move or not move?
Moved.
The question is that Amendment 29 be agreed to. Are we all agreed? Yes. We are not agreed. There will be a division. Those in favour of Amendment 29? Those against? Any abstentions? The result of the division on Amendment 29 is 2 for, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 16 in the name of Maggie Chapman, already debated with Amendment 9. Maggie Chapman, to move or not move?
Moved, convener.
Okay. The question is that Amendment 16 be agreed to. Are we all agreed? Yes. We are not agreed. Those in favour of Amendment 16? Those against? Any abstentions? Thank you. The result of the division on Amendment 16 is 4 for, 3 against and no abstentions. The amendment is therefore agreed to. I call Amendment 30 in the name of Tess White, already debated with Amendment 21. Tess White, to move or not move?
Moved.
The question is that Amendment 30 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 30? Those against? Any abstentions? The result of the division on Amendment 30 is 2 for, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 6 in the name of Pam Gossel, already debated with Amendment 21. I remind members that if Amendment 6 is agreed to, I cannot call Amendment 17 due to preemption. Pam Gossel, to move or not move?
Moved.
Thank you. The question is that Amendment 6 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 6? Those against? Any abstentions? The result of the division on Amendment 6 is 2 for, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 17 in the name of Maggie Chapman, already debated with Amendment 9. Maggie Chapman, to move or not move?
Moved.
The question is that Amendment 17 be agreed to. Are we all agreed? Yes. We are not agreed. Those in favour of Amendment 17? Those against? Any abstentions? The result of the division on Amendment 17 is 4-4, 3 against. The amendment is 0 abstentions. The amendment is therefore agreed to. I call Amendment 31 in the name of Tess White, already debated with Amendment 21. Tess White to move or not move?
Moved, Convener.
The question is that Amendment 31 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 31? Those against? Any abstentions? Okay, the result of the division on Amendment 31 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 32 in the name of Tess White, already debated with Amendment 21. Tess White to move or not move?
Moved, Convener.
The question is that Amendment 32 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 32? Those against? Any abstentions? The result of the division on Amendment 32 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 33 in the name of Tess White, already debated with Amendment 21. Tess White to move or not move?
Moved, Convener.
The question is that Amendment 33 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 33? Those against? Any abstentions? The result of the division on Amendment 33 is 2-4, 4 against and 1 abstention. The amendment is therefore disagreed to. I call Amendment 34 in the name of Stephen Kerr, already debated with Amendment 21. Tess White to move or not move?
Moved, Convener.
The question is that Amendment 34 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 34? Those against? Any abstentions? The result of the division on Amendment 34 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 1 in the name of Maggie Chapman, grouped with Amendments 18, 3 and 4. Maggie Chapman to move Amendment 1 and speak to all amendments in the group.
Thank you, Convener. The child-facing version of the UNCRC says, I have the right to be listened to and taken seriously. However, the 1980 Act allows children to be withdrawn from religious activities in schools without their consent and without even taking their views into account. That is clearly contrary to the Convention, and I welcome the bill's opportunity to correct that. As it stands, however, the bill allows a young person to opt back in to those religious activities if they have previously been opted out by their parents, but not to opt out themselves. That directly contradicts the Scottish Government's draft child rights scheme, which says that it wants to give children, and I quote, the knowledge and confidence to use their rights. That suggests, rightly, that children should be able to use their rights proactively and not only after an adult has acted on their behalf. The bill goes against the Children and Young People's Commissioner Scotland, who was explicit in her letter to the committee, in which she said, Part 1 in its current form does not achieve compliance with the UNCRC. Her view is shared by others. The committee's Stage 1 report also notes that a majority supported amending the bill to provide children with an independent right to withdraw from religious observance. That majority includes the Scottish Human Rights Commission and, together, the Scottish Alliance for Children's Rights. Professor Angela O'Hagan of the Scottish Human Rights Commission told the committee that, without such a right, the bill will fail to meet its basic aim of achieving compliance with the UNCRC. In its 2023 concluding observations on the rights of the child in the UK, the UN also called for withdrawal requests by children and young people not to be subject to parental consent. If all that was not enough, a Survation poll recently commissioned by the Humanist Society Scotland shows that 66% of Scots believe that pupils should be able to decide for themselves whether to take part in religious observance or not. And the majority of supporters of every political party agree. So, Convener, it is central to the whole notion of the rights of children and young people that they should not be subsidiary to the actions of adults. By allowing young people to override their parents' wishes but not proactively exercise their own rights, this bill undermines its central purpose to strengthen the fundamental rights to be heard, taken seriously and listened to. I am grateful in the overwhelming support that I've received for these amendments from civic society, from people who of faith and people of none. This is about giving children and young people the right to exercise their rights under UNCRC to choose whether or not to be subjected to religious observance. And I urge committee to follow the committee's recommendations, to follow the evidence we heard in our Stage 1 evidence gathering, and to follow the overwhelming support of information we've had and support these amendments. Thank you.
Thank you very much, Convener. I have followed this debate at Stage 1 and obviously now I've rejoined committee at Stage 2. So I would echo previous concerns about the nature of trying to have a debate of this magnitude and depth with only 3 months remaining in the parliamentary session. And it's perhaps for that reason that I want to just try and explore a bit more some of the detail within what is being advocated by Maggie Chapman and by others. I do have a concern that whilst I recognise what is being said about UNCRC and the rights of children and young people, I do think that we have to look in full at the detail of what is actually said within UNCRC and in particular Article 14, because Section 2 of Article 14 on the rights to freedom of belief and religion states that state parties shall respect the rights and duties of the parents and, when applicable, legal guardians to provide direction to the child in the exercise of his or her right in a manner consistent with the evolving capacities of the child. So I think throughout this process, I think people are trying to achieve a degree of balance, which I think is what is important, because I do think there is a balance between absolutely trying to hear quite clearly the voice of children and young people, but also giving due regard and respect to the rights of parents, and particularly given that as a state party there is legislation, pre-devolution legislation and post-devolution legislation that outlines quite clearly the rights of parents to direct their child and to support their child in terms of decisions that are taken. So I don't detect within the amendments before us a reference to that and to the rights of parents to be involved and for each individual state party, as I say, to take their own view on how that involvement should take place and how it should look. So I do think there is a sort of we need to be more nuanced, I think, in terms of the approach and not ignore other significant parts of UNCRC that are also before us. So I think it would be helpful to me if Ms Chapman could clarify whether she disagrees with those provisions within UNCRC and what place she feels that there is for parents within that process. Because, as I've just noted, UNCRC leaves a balance of those matters at the discretion of state parties and having been established in Scots law, the right to direct their child, there is clearly precedent. I do think, however, there is perhaps further discussion to be had about how we balance those rights and balance those duties. And it's certainly something that I would be interested in having further discussion on as we approach stage 3. Because I am concerned that the amendment as drafted may bring that conflict that we're talking about, and those fundamental conflicts that exists between the competing, well, competing is perhaps not the right word, but the interacting rights of both parents and children. I also am concerned that there hasn't been a huge deal of scoping work on how widely any new right on the part of children might be used and how it might impact on school leaders and on teachers and on some of the issues that we discussed in the previous grouping around the conflicts that will exist within school. I think we have to be cognizant of unintended consequences of how things might work in practice, and again, particularly in denominational schools. And I've already talked earlier about there not being now clear distinctions in terms of RE and RO, and children choosing to opt out of one and not the other. So I am concerned about that impact. I think there could be a number of unintended consequences. And again, the bill highlights, I think, the frustration of dealing with such fundamental issues, as I've said already, in a constrained bill and in a constrained timeframe. So I think recognising all of that, I am not able to support this amendment as is currently before us today. But I am interested in having a further discussion about that balance of rights and that interplay of rights, because I do think that is important. Thank you.
Cabinet Secretary.
Convener, Amendments 1, 18, 3 and 4 in the name of Maggie Chapman, as we have heard, seek to introduce an independent right for pupils to withdraw themselves from religious observance in schools. I've been clear in my evidence and in responding to the committee's Stage 1 report that the bill as introduced seeks to strike a careful balance, as I think we've just heard from Mr O'Kane, by providing pupils with a right to object to their withdrawal, but requiring that a discussion on that objection is sought between school, parent and pupil. These changes uphold pupils' rights while recognising the rights of parents to provide direction and guidance to their children in line with their evolving capacities. Also, as the committee noted in its Stage 1 report, responses to the public consultation were far from definitive in their support for the independent right for pupils to withdraw from religious observance. And indeed, the committee recommended that further consideration be given to this option in future legislation, and the majority of the committee considered that the current approach in the bill would be more appropriate at this juncture. I welcome that position and I consider it the right approach. The current bill provisions aim to chart a middle course in the spectrum of stakeholder views, introducing the requirement to consider the child's views as part of any withdrawal request. This approach aligns with the requirements of Article 12 and represents a clear improvement in the consideration of children and young people's views on withdrawal from religious observance and/or RME. The introduction of an independent right to withdraw raises a range of questions about the interaction of parental and children's rights, again, I think, as we have already heard, as well as for the delivery, the timetabling and the staffing of religious observance and alternative activities in school. These matters alone would warrant further analysis and formal consultation, including to establish the associated costs, which can be expected to be significant. In order to establish these amendments to be debated at Stage 2, we've had to provide a financial resolution in acknowledging the implementation of these amendments, if passed, would have costs that take us over the threshold for such a resolution. And I should say I was happy to do so to enable this debate to take place at Stage 2. However, for the reasons I've set out, I cannot support the amendments in this group, nor the introduction of an independent right for pupils to withdraw from religious observance in the bill.
Thank you. The question is that, apologies, Maggie Chapman, to wind up, press or withdraw Amendment 1. I didn't skip you, Maggie.
Thanks, Karen. Thank you. In closing, Convener, no young person should be forced to pray. No young person or child should be forced to participate in activities of worship against their will. That is the principle to which these amendments speak. Young people in Scotland schools are still compelled to participate in acts of religious observance. In reserving the right to withdraw exclusively to parents, some school pupils and young people are denied the right to be heard and are forced to pray against their own beliefs. This was the clear conclusion from the Preaching is Not Teaching report that the Humanist Society Scotland published. This report also found that RO is still exclusively Christian and worship-based in many non-denominational schools. Twice, the UN has recommended that children and young people in Scotland are supported to exercise their rights by giving them the right to withdraw from RO. My amendments seek to answer that recommendation that the UN has made on us twice in the last 8 years. All of the human rights experts we heard from in committee were very clear. Children and young people should be able to exercise their right to freedom of belief and expression. Faith groups, legal experts, human rights bodies have all told us that denying pupils the independent right to withdraw amounts to a breach of their human rights. And my amendments seek to address that breach and enable children to exercise their right to freedom of belief and expression. Thank you.
Thank you. The question is that Amendment 1 be agreed to. Are we all agreed?
Yes.
No, we're not agreed. There will be a division. Those in favour of Amendment 1? Those against? Any abstentions? The result of the division on Amendment 1 is 1 for, 6 against, no abstentions. The amendment is therefore disagreed to. I call Amendment 35 in the name of Tess White, grouped with Amendments 38, 39 and 43. Tess White to move Amendment 35 and speak to all amendments in the group.
Thank you, Convener. Cabinet Secretary and Committee. These amendments are about basic transparency and making sure we understand how the system is working in practice. At stage 1, we heard concerns without proper data. It will be difficult to know whether the bill is having unintended effects on children, families or schools, and these amendments address that gap. Amendment 35 makes a small but important technical change by linking the reporting duty to the new definitions in the bill so that data on withdrawals is recorded consistently and clearly. This helps ensure that information is accurate and comparable across schools and local authorities. Amendment 39 introduces a clear reporting requirement by requiring schools to report annually on requests for withdrawal from religious instruction and religious observance. It also requires reporting on how often pupils objected to a parental request and how often those objections were upheld. This amendment doesn't ask schools to record beliefs or motivations. It simply collects information on how the process is being used and where the disagreements are arising. Thank you.
Thank you. Paul O'Kane to speak to Amendment 38 and other amendments in the group.
Thank you, Convener. I don't intend to speak for long, as many of the underlying arguments are similar to those that have been expressed by Tess White, and I'm sure by Maggie Chapman also. The committee was concerned at stage 1 about the fact that when it comes to religious observance practices and withdrawal from both RO and RE, we do not have good or accurate data on what is currently happening in schools. That's a concern I share, and I believe colleagues in committee also share. I think it's important that we have something in the provisions of the bill in order to collate and collect the data in an appropriate way to understand what is happening across Scotland. I think in her reflections on stage 1 evidence, in fairness, the Cabinet Secretary would accept that point and accepts the data being collected is perhaps not sufficient and could be better. I'm also very mindful of putting further burdens on schools and on local authorities, but I do think there is something here where we could perhaps find the most appropriate way between government and the members of the committee in order to move this forward. So I'm willing not to move the amendment today if the Cabinet Secretary will provide an assurance that we can work together on the monitoring and transparency elements of the bill and perhaps come back at stage 3 with something that would work to fulfil, I think, what we all want to see, which is we have an accurate picture of all of these issues across Scotland. Thank you.
To speak to Amendment 43 and other amendments in the group.
Thank you, Convener. All of the amendments in this group are trying to do similar things in reporting on the exercise of rights to withdraw. It is right that we monitor how rights are being used and respected, and I support the intention of all the amendments in this group. My Amendment 43, I think, is the most comprehensive. Not only does it allow us to monitor things, but it also updates us on the use of religious observance itself. Some schools have followed Scottish Government guidance and adopt a time for reflection model of religious observance. This more inclusive approach is less focused on prayer and religious worship, more about reflecting on a moral issue without being led in a particular way of thinking. Schools tend to invite a range of speakers from different faith and non-faith backgrounds. However, research from the Humanist Society Scotland shows that in some non-denominational schools, RO is still wholly or largely delivered in a Christian manner. Assemblies are held in church, involve religious worship, prayers and hymns. Non-inclusive practices such as these can isolate and discriminate against pupils, parents, guardians and teachers who do not hold Christian beliefs. That is why it is important to monitor how RO is taking place in our schools, which is covered by paragraph 2A in my amendment. Where students do withdraw from RO, it's crucial that high-quality alternative provision is put in place so these young people are not disadvantaged, and paragraph 2C covers this. I hope the committee will support my amendment so that we can ensure rights that we are creating in law are being used effectively across our educational system, and that religious observance in our schools is delivered in a way that is appropriate, inclusive, and understands that we exist in a multi-faith society. Thank you.
Thank you. Cabinet Secretary.
Convener, I thank Tess White, Paul O'Kane and Maggie Chapman for explaining the rationale between these quite similar amendments, though there are, I acknowledge, some important differences. I also note the committee's conclusions on data and evidence, as was set out in the Stage 1 report, and I think, as we've already heard today, that the government undertakes research to better understand how withdrawal is monitored and to better monitor the number of withdrawal requests. Now, in response to the Stage 1 report, I confirmed that I would give consideration to those recommendations, which Group 4 also speaks to. And while I welcome the intention behind these amendments, I do have some difficulties with each of them. Paul O'Kane's Amendment 38 and Tess White's Amendment 39 are very similar in that they seek to place a data gathering and reporting duty on operators of schools to give specific items of data to ministers, accompanied by annual duties on ministers to collate that data and to publish analysis of the report. Operators of schools are, of course, either education authorities, so local authorities, or the charitable bodies which run our grant-aided schools. And in relation to Mr O'Kane's amendment, the specific part of that amendment requiring schools to monitor and then report on instances of religious observance would seem to be impractical. And although I note he has already acknowledged this point, the bureaucratic burden for each school to report on this to each education authority on each occasion does seem to be disproportionate. In relation to Tess White's amendment, the requirement to report on instances of pupil objections and where those are given effect may give rise to concerns about privacy, in particular given the estimated low frequency of withdrawals, even without a requirement for Scottish ministers to publish that information. So on that basis, I'm not able to support Amendments 35, 38 and 39 as drafted. Now, Maggie Chapman's Amendment 43 seeks to tackle those matters through a very different method via the commissioning of an independent report by the government 2 years after royal assent and then 5 years thereafter. This would cover the form and content of religious observance in schools, the operation of the withdrawal rights from religious observance, the extent to which alternative education experiences are provided to pupils, and compliance with the UNCRC in relation to the form of religious observance provided, and the arrangements for withdrawal from religious observance and any other matters deemed important by the independent body tasked with developing that part. Now, I understand the intention behind Maggie Chapman's Amendment 43, but it's not clear how the costs of providing such a report and the need to gather data and information to include in it would be funded. It is also not clear what the purpose of each element would be and if that would have a benefit proportionate to the requirement to gather that data. So, for example, happy to give way.
Thank you, CabSec. I mean, I think following on from what Paul O'Kane was saying, the Stage 1 evidence, there were a lot of unknowns. These are a lot of the figures are projected or estimated, or I mean, it's guesswork, quite frankly, because we don't understand necessarily that we don't have a picture of what's happening now. Never mind when new rights come into play. And I just wondered what mechanism the Cabinet Secretary or the Scottish Government thinks is important to gather data, so we do actually understand what's going on in this area.
So I recognise the member's point. I think we need to be mindful that data gathering is proportionate. I'm also cognizant of the fact that the statutory responsibility for the delivery of education rests with local authorities. So they quite often sit with lots of data, and those who have debated with me on education matters in the Chamber will know that data rests at local level quite often. And I recognise some of the challenge in that regard. So I think there is a need for better data gathering. I recognise that in my evidence to committee at stage 1 and in the debate. I think there's a more proportionate way we might be able to provide for that, and I'll come on to talk to that in more detail. But overall, while I agree there should be appropriate monitoring on the matters addressed in the legislation, as I did note during the stage 1 debate, I do have some difficulties with what each of those 3 amendments is seeking to cover. So I would welcome the opportunity to consider this further with a view to bringing back a suitable amendment at stage 3 that seeks to fulfil the committee's recommendations at stage 1, and I would therefore ask Tess White, Paul O'Kane and Maggie Chapman not to press their respective amendments on that basis.
Thank you. Tess White, to wind up, press or withdraw Amendment 35.
Thank you. Cabinet Secretary, you'll be hopefully pleased to hear that, based on what you've just said, that you will consider, take them away, review them, and then come back. I won't press my amendments, so I just say thank you for that, and we look forward to, definitely myself, look forward to working with you on that. Thank you.
Thank you. So Tess White seeks to withdraw Amendment 35.
Yes, I withdraw 35 and 39.
Okay, it's just 35 at the moment. Does any member object to Amendment 35 being withdrawn? No. Okay. So there are no objections, so the amendment is withdrawn. So I call Amendment 36 in the name of Tess White, grouped with Amendments 37, 41, 57 and 58. Tess White to move Amendment 36 and speak to all amendments in the group.
Thank you, Convener. So in this group, which is guidance on withdrawals, it's about making sure schools are properly supported to implement the bill, and that families can expect a consistent approach across Scotland. So at stage 1, as a committee, we heard clear evidence from schools, local authorities and teachers that without clear national guidance, this bill risks being applied differently from one area to another, and these amendments respond directly to those concerns. Amendment 36 and 37 strengthen the existing guidance provisions by requiring schools to have a regard to guidance published by Scottish ministers, rather than guidance that may be issued. This ensures that guidance is not optional and gives schools a clear national framework to follow. Amendment 41 places a clear duty on the Scottish ministers by requiring them to prepare and publish statutory guidance on how the new withdrawal process should operate. And it also specifies what that guidance must cover, including how to assess a pupil's maturity, how to handle disagreements, what support is available, what training is needed, and how the process will be resourced. And importantly, Cabinet Secretary and Committee, this amendment also requires Scottish ministers to consult education authorities, teachers, parents, before the guidance is published, that helps ensure the guidance is practical and grounded in real experience. And finally, Amendments 57 and 58 link the guidance directly to commencement. They ensure that the main provisions of the bill can't come in force until the guidance has been published, and that avoids schools being expected to implement complex new duties without the tools or support they need. Thank you.
O'Kane, please.
Thank you, Convener. The only comment I wish to make in this grouping is to reiterate the comments I made in Group 2. The Government needs to provide clarity on how it sees changes as proposed being carried out. I do agree with the intent behind the amendment, but there are significant concerns about implementation to the changes proposed in the bill, so therefore there is a clear need for guidance for our schools and our teachers. So I'm certainly supportive of a general amendment requiring ministers to set out guidance. However, whether the amendment as drafted by Tess White is the right way to go about that in terms of prescribing contents of guidance is not something that I am convinced of. But I do think it provides another opportunity for the Cabinet Secretary to set out that she will provide and produce guidance, and perhaps to detail what she sees as being necessary within that, and any other support for schools and teachers in that regard. Thank you.
Thank you. Cabinet Secretary.
As we've heard, Tess White's amendments in Group 5 relate to the introduction of a new duty which would require Scottish ministers to prepare and publish guidance for school operators on matters relating to the process for withdrawing from RO and RME. This would replace the existing requirement in the bill for operators to have regard to any guidance that the Scottish ministers may give. Amendments 36, 37, 57 and 58 are consequential to Amendment 41, so I will speak substantively only to that amendment. The Government recognises the importance of guidance, as I think we've heard from Mr O'Kane, to support schools and teachers in implementing these changes, and that there have been calls for the updated guidance to provide greater clarity. I committed to publishing updated guidance during my Stage 1 evidence in October. However, while the principle of including a duty rather than a power to publish guidance is accepted, the Government cannot accept Amendment 41 as drafted. We would want to engage with stakeholders to ensure that those matters in the guidance are required to cover are the most appropriate, and also to consider the consultation requirements so that in preparing the guidance we are properly reflecting the views of schools, parents and children. So I therefore seek the opportunity to undertake that engagement and to consider further what a duty to provide guidance should look like and cover, and would commit to bringing back a suitable amendment at Stage 3. So for those reasons, I would ask Tess White not to press Amendment 41 and the associated consequential amendments.
Thank you. Tess White, to wind up, press or withdraw Amendment 36.
Thank you, Convener. Subject to what the Cabinet Secretary has just said, that Cabinet Secretary, you're willing to take this away and look at it, and do recognise the importance of guidance and had intended to do so, I won't press these amendments. Thank you.
Okay. Okay, so Tess White seeks to withdraw Amendment 36. Does any member object to the amendment being withdrawn? There are no objections, so the amendment is withdrawn. I call Amendment 18 in the name of Maggie Chapman, already debated with Amendment 1. Maggie Chapman, to move or not move?
Moved.
Moved. The question is that Amendment 18 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 18? Those against? Any abstentions? The result of the division on Amendment 18 is 1 for, 6 against, no abstentions. The amendment is therefore disagreed to. I call Amendment 3 in the name of Maggie Chapman, already debated with Amendment 1. Maggie Chapman, to move or not move?
Not moved.
Not moved. Okay. I call Amendment 4 in the name of Maggie Chapman, already debated with Amendment 1. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 37 in the name of Tess White, already debated with Amendment 36. Tess White, to move or not move?
Not moved.
I call Amendment 38 in the name of Paul O'Kane, already debated with Amendment 35. Paul O'Kane, to move or not move?
Not moved.
Moved. I call Amendment 39 in the name of Tess White, already debated with Amendment 35. Tess White, to move or not move?
Not moved.
I call Amendment 40 in the name of Maggie Chapman in a group of its own. Maggie Chapman, to move and speak to Amendment 40.
Thank you. Sorry, just find my notes. Here we are. Thank you, Convener. My Amendment 40 has the same aim as my other amendments this morning, and the same aim as the original bill in terms of the rights of children and young people. It ensures that young people can be heard in any decision made by their parents to withdraw them from religious observance. However, the key difference is that the provisions are enacted as a standalone provision, rather than as amendments to the 1980 legislation. Together argues that this places the bill out with the scope of the UNCRC Incorporation Scotland Act 2024. This means children would have no direct route to challenge breaches of their rights in relation to these new provisions, given our current situation with UNCRC incorporation. As well as the separation of religious education and observance and the independent right to withdraw, this is one of the three key changes requested by Together in its letter to the committee of 13th of October this year. These are designed to ensure Part 1 of the bill fully aligns with UNCRC. Whilst I appreciate the Commissioner has not taken a position on Amendment 40, she has made the same call as Together for the right to be established separately from the 1980 Act for the reasons I've outlined above. And for these reasons, I move Amendment 40 in my name.
Thank you. Cabinet Secretary.
Convener, Amendment 40 in the name of Maggie Chapman seeks to remove Section 1 of the bill and replace it with a new section which makes similar provision for seeking the views of pupils in response to the exercise of the parental right to withdraw their child from religious education, but with a notable technical change, as I think we have just heard. The new section would create a standalone provision within the bill rather than amending the Education Scotland Act 1980. That change would mean that this new section falls within the scope of the compatibility duty in Section 6 of the UNCRC Incorporation Scotland Act 2024. However, the parental withdrawal right itself would remain in the 1980 Act. Making this freestanding provision risks losing important definitions and safeguards which are contained within the 1980 Act, such as Section 28, which sets out the general principle that children should be educated in accordance with the wishes of their parents so far as possible. Splitting the process for pupils gives views from other provisions relating to RME and religious observance means the legislation would be fragmented and much less coherent. The 1980 Act is a major, long-standing piece of legislation underpinning Scotland's education system. It makes provision for religious observance in schools and the right of parents to withdraw their child from religious observance. Amending it so that the legal basis for religious observance, the parental right to withdraw, and the process for the child's involvement in the process are in one place is the most pragmatic approach for clarity, coherence and workability. Happy to do so.
Thank you for taking my intervention, Capsec. I suppose I just have a question around, and I understand what you say about pragmatism in this approach, but drafting the bill in such a way to ensure that UNCRC wasn't entertained or couldn't be, that does seem odd. And I think odd at best, problematic at worst. The first opportunity the Scottish Government has to expand children's rights and to do so in a way that allows the test against UNCRC compatibility to come into play, and you've chosen a different route. I would just like a little bit more understanding of why that was the case.
I think, as I said in my evidence to committee at stage 1, we've chosen the 1980 Act because it's the 1980 Act that makes provision in relation to religious observance and RME and the right to withdraw. So that's the source that we need to look at. And of course, for all the reasons that Maggie Chapman rightly sets out in relation to the UNCRC, that's why, of course, we are amending the legislation to ensure that children's rights are given cognizance of in relation to the right to withdraw. We are not removing, though, the parental right, and we're not creating a standalone opportunity to deliver on what we intend to deliver on, because we think that would create incoherence, as I've already alluded to. There are lots of other issues that the member will know of in the education sphere that other members might be interested in legislating for, but our view is to legislate at source, and that is the 1980 Act. But reenacting, to my point, those isolated provisions does risk a level of duplication and confusion. It wouldn't be proportionate to move multiple sections of the 1980 Act into this bill, particularly given the targeted and the technical nature of the proposed changes. And if we did try to do that, it would have made this a much bigger restatement project than a 5-page bill as it currently is, and would not have been possible in the parliamentary time that we have left for this bill. So I do acknowledge that a majority of committee members in the Stage 1 report indicated their disappointment that this bill is proceeding out with the scope of the compatibility with the UNCRC Act. However, their view concurs with government's in that making significant amendments at Stage 2 to bring the bill in scope of the UNCRC Act would not be easily achievable. I do recognise the concerns about Part 1 of the bill being out with the scope, as we've mentioned, just as the 1980 Act is, of course, out with its scope. The 2021 judgment by the Supreme Court on the UNCRC bill highlighted the complexities of human rights incorporation in a devolved context, and these complexities are at the root of this issue. But the government recently committed to address this issue of the limited scope of the compatibility duty in the UNCRC Act in the Children's Rights Scheme, which was laid before Parliament on the 20th of November last month. And it states that we will progress engagement with the UK government to explore the removal of any legislative restrictions that currently limit the Scottish Parliament's ability to enhance human rights protections across all areas devolved to Scotland. Additionally, the Government has set a deadline of November 2026 next year for progress to be made in finding a more straightforward and effective route to extending protection for children's rights. If sufficient progress is not made by next year, we will commission a review of the provisions in the Acts of the Parliament of the United Kingdom in devolved areas. This review would identify any key provisions that interact with children's rights to such an extent that it may be worth reenacting them as acts of the Scottish Parliament to bring them into scope of the compatibility duty. In the meantime, attempting to make this very limited change is not an effective way of addressing the issue and will create more complexity for parents, children and schools, and for those reasons I'm not able to support Amendment 40 and I would urge members to resist it.
Thank you. Maggie Chapman, to wind up, press or withdraw Amendment 40.
Thanks very much, Convener. Just briefly, I think it's worth stressing mine and many others' disappointment that by choosing to amend the 1980 Act, the Cabinet Secretary has ensured that the provisions covered by this are out of scope of our own UNCRC Incorporation Act compatibility duty. And I think that sends a really, really worrying signal to people with an interest in the space. We should have taken the time and the care to ensure that this legislation was in scope. If that meant taking longer to do it, I think that is what we should have done. But given we are where we are and we have this bill in front of us, I do think that we need to make it, we need to bring these rights into scope of UNCRC incorporation, and so therefore I will press Amendment 40.
Thank you. The question is that Amendment 40 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 40? Those against? Any abstentions? The result of the division on Amendment 40 is 1 for, 6 against and 0 abstentions. The amendment is therefore disagreed to. Thank you. Yeah. So I call Amendment 41 in the name of Tess White, already debated with Amendment 36. Tess White, to move or not move?
Not moved.
Not moved. I call Amendment 42 in the name of Tess White, already debated with Amendment 21. Tess White, to move or not move?
Not moved.
I call Amendment 43 in the name of Maggie Chapman, already debated with Amendment 35. Maggie Chapman, to move or not move?
Not moved.
I call Amendment 44 in the name of Stephen Kerr, already debated with Amendment 9. Tess White, to move or not move?
Not moved.
Thank you. At this point, we're going to suspend briefly for 5 minutes for a comfort break. Thank you. Thank you and welcome back. I call Amendment 45 in the name of Stephen Kerr, grouped with Amendments 46, 47, 48, 49, 50 and 52. Tess White to move Amendment 45 and speak to all amendments in the group.
Moved, Convener. Convener, Cabinet Secretary and Committee. The amendments in this group seek to place clear and necessary limits on the scope of the exemption. Several of the amendments require that the incompatibility must be created by express and specific statutory wording, not by implication, interference or administrative preference. And that's the purpose behind amendments 45, 46 and 48. If the Parliament intends to compel an action that is incompatible with the UNCRC requirements, it should do so openly and explicitly. It should not be left to public authorities to speculate or to interpret ambiguity. Amendments 47, 49 and 50 add a further essential safeguard. They require that an exemption may only be relied upon when no reasonable alternative exists that would allow the public authority to act compatibly with the UNCRC. This reflects a basic principle of good governance. It should never be easy or casual for a public authority to set aside a compatibility duty. Amendment 52 is a standalone provision that reinforces the principle that such exemptions cannot become a catch-all defence. It prevents Section 2 from being used in a way that unnecessarily weakens the compatibility duty or confers broad discretion on ministers or public authorities. Cabinet Secretary, Committee and Convener, these amendments don't challenge the existence of a compatibility duty, nor do they challenge the government's broad intentions in bringing forward this bill. They simply ensure that an exemption from a human rights obligation is treated with the seriousness it deserves. These amendments offer what hopefully the Cabinet Secretary will see as constructive solutions to a problem the government has not fully addressed. They promote clarity, transparency and proportionality, which is a word that the Cabinet Secretary has used a few times today. They preserve the integrity of the compatibility duty without undermining the Parliament's ability to legislate in areas where a conflict might genuinely arise. In short, they make Section 2 workable, understandable and properly bounded. Thank you.
Thank you. Cabinet Secretary.
Convener, constructive solutions from Stephen Kerr. Let me speak to the amendments. Amendments 45, 46, 47 and 52 all seek to alter Section 6A of the UNCRC Act, which restates the existing exemption relating to incompatibility action required or authorised by legislation which originates from the UK Parliament. It's important to be clear at the outset that the Section 6A exemption for the UK Parliament legislation is not new. It restates Section 6.4 of the UNCRC Act and it's therefore already part of the UNCRC Act. It's not changed in substance by this bill. It is only included here to restate the exemption for drafting clarity alongside the new Section 6B exemption relating to certain Scottish legislation. Now, members will recall that this exemption for incompatibility action required or authorised by legislation which originates from the UK Parliament was added to the UNCRC Act at reconsideration stage following the Supreme Court judgment and was developed following engagement with the UK Government. The amended UNCRC bill, brought forward for reconsideration and passed unanimously by the Parliament, was designed to carefully balance three important considerations. 1, protecting children's rights to the maximum effect possible. 2, minimising the risk of another Supreme Court referral. And 3, making the law as accessible as possible for users. Reopening wording or conditioning the use of the 6A exemption risks undermining the balance that was struck to secure safe passage of the Act and could risk a further Supreme Court referral on legislative competence grounds. These amendments are therefore problematic and put the UNCRC Act at risk. Convener, amendments 48, 49 and 50 seek to alter Section 6B of the UNCRC Act, which is the new exemption being introduced by the bill for situations where a public authority is required by certain Scottish legislation to act incompatibly with UNCRC requirements. I've been clear in my evidence at stage 1 that this exemption should only be used where absolutely necessary. Accordingly, the exemption introduced through the bill is already deliberately narrow in scope. Amendment 48 would not narrow the exemption in practice. It would do the opposite. It would allow a public authority to rely on the exemption where it is entitled to act incompatibly, which gives the public authority more discretion to apply the exemption. Our approach to Section 6B means that the exemption can only apply where a public authority is required to act incompatibly in order to maintain a tightly drawn exemption. Our narrow approach was welcomed by the Children's Commissioner and also by Together, whose interest in protecting and enhancing children's rights can be relied on. And again, I think it is worth considering the motivation behind the amendments, which in practice would make it easier for authorities not to act compatibly with children and young people's rights. Now, in relation to Amendments 49 and 50, the exemption is already designed to operate only where an Act of the Scottish Parliament leaves a public authority with no discretion to act compatibly. Public authorities and courts must already read and give effect to such legislation in a way that is compatible with UNCRC requirements, wherever that is legally possible. So this approach is well understood in practice. It reflects a long-established model under the Human Rights Act. Adding further conditions, for example, requiring express and specific statutory words, or introducing a separate test that the exemption can only apply where there are no alternative compatible means, does not add protection in practice, as these safeguards are reflected in the UNCRC's Act's interpretation obligation. Instead, it risks departing from that established framework and undermining the legal clarity and certainty for public authorities that this bill is intended to provide. For all these reasons I've set out, I consider these amendments unnecessary and problematic, and I would ask that members do not, I would ask that Tess White does not press them on behalf of Mr Kerr.
Tess White, to wind up, press or withdraw Amendment 45.
Thank you. Convener, if I may, before I make a decision on whether to press or withdraw, I'd like to just ask the Cabinet Secretary about sections 131 and 132 of the Stage 1 report, and I'll read it out. So in paragraph 131, it says, fundamentally, many witnesses argued that the Scottish Government has not made a case for why Part 2 of the bill is needed. And Dr Hill, who was a witness to the committee, told us the amendments made in Part 2 of the bill are trying to address a problem, the extent of which we are not really clear on, in a way that is disproportionate to the impact that it would have on children's rights. And paragraph 32 says this view was echoed by Caitlin Fitzgerald of the SHRC, and she said, and I will quote, the Scottish Government's position seems to be that it does not think that there are any current incompatibilities. However, we respectfully urge some caution in accepting that position, given that we have not seen the Scottish Government's working. That links back to the issue that we discussed about what the Scottish Government has done to assess what is currently on its statute book and how it fits with UNCRC obligations. The more we might be speaking about unknowns, the more that exacerbates the issues that we have expressed about access to justice and the potential dilution of the rights. So I think what Stephen Kerr, as we've said, is trying to add something constructive so that you've got something to hang upon, which to many witnesses just felt like fog and really can't understand what Part 2 is about. And I did try to put some amendments to Part 2, but I was told that I couldn't, so I had to withdraw those. So before I press or withdraw, Cabinet Secretary, do you have any view on that?
So, in summation, Part 2 of the bill is a future-proofing power. We discussed this at Stage 1. It mirrors some of the approach that's taken in the Human Rights Act, although it's actually much narrower in scope, the approach that we've taken. And I also note that the member cited evidence from the Stage 1 report, but it's important to record that a number of other organisations are supportive of the approach that the government has taken. I gave examples in my contribution previously, but for example, Together, the Children's Commissioner, UNICEF UK are supportive of our approach to the exemption, and they did not call for changes to the operation of the exemption itself, as the amendment set out. The Children's Commissioner explicitly welcomed that the proposed amendment only applies where a public authority is required to act incompatibly. And additionally, as part of our initial engagement with some public authorities, they've said the amendments appear to add a further complexity and burdens in relation to interpretation from Mr Kerr. So I hope that that's perhaps reflected by Ms White's stance, and we can agree that this more narrow approach that the government is providing for is more optimal.
Thank you, Cabinet Secretary. I think we're still perplexed, scratching our heads on it, and just can't understand why it's been put forward. And I think clarity is required. So I will be pressing the amendments.
Okay, the question is that Amendment 45 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 45? Those against? Any abstentions? The result of the division on Amendment 45 is 2-4, 5 against, no abstentions. The amendment is therefore disagreed to. I call Amendment 46 in the name of Stephen Kerr, already debated with Amendment 45. Tess White to move or not move.
Moved, Convener.
The question is that Amendment 46 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 46? Those against? Any abstentions? The result of the division on Amendment 46 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 47 in the name of Stephen Kerr, already debated with Amendment 45. Tess White to move or not move.
Moved, Convener.
The question is that Amendment 47 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 47? Those against? Any abstentions? The result of the division on Amendment 47 is 2-4, 5 against and no abstentions. The amendment is therefore disagreed to. I call Amendment 48 in the name of Stephen Kerr, already debated with Amendment 45. Tess White to move or not move.
Moved, Convener.
The question is that Amendment 48 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 48? Those against? Any abstentions? The result of the division on Amendment 48 is 2-4, 5 against, 0 abstentions. The amendment is therefore disagreed to. I call Amendment 49 in the name of Stephen Kerr, already debated with Amendment 45. Tess White to move or not move.
Moved, Convener.
The question is that Amendment 49 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 49? Those against? And any abstentions? The result of the division on Amendment 49 is 2-4, 5 against, 0 abstentions. The amendment is therefore disagreed to. I call Amendment 50 in the name of Stephen Kerr, already debated with Amendment 45. Tess White to move or not move.
Moved, Convener.
The question is that Amendment 50 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 50? Those against? Any abstentions? The result of the division on Amendment 50 is 2-4, 5 against, 0 abstentions. The amendment is therefore disagreed to. I now call Amendment 51 in the name of Maggie Chapman, grouped with Amendments 53, 54, 7 and 8. Maggie Chapman to move Amendment 51 and speak to all amendments in the group.
Thank you very much, Convener. There's a certain amount of irony in this bill, given that it brings school religious activities into line with the Convention. Yet in Part 2, provides for a very wide exception to Convention rights where there is conflict between the Convention and existing legislation. Not just in relation to the religion in schools issue, but any issue at all. Let's be clear what's happening here. We have just incorporated the Convention into our laws, and we are now allowing potentially very broad opt-outs from it. Instead of working out where there are incompatibilities and addressing these where we have the power to do so, we are allowing a blanket carve-out. I'd wanted to discuss this morning much more detailed amendments to tackle this, but these were ruled out of scope, unfortunately. However, in dealing with this issue, the Children and Young People's Commissioner, together, and the Scottish Human Rights Commission have all warned the need to tread very carefully here. My Amendment 51 helps us to do that, I think, and I move Amendment 51. Where a body relies on Section 6, they must notify the Scottish Government and Commissioner, and then the Scottish Government must report annually on all notifications they have received on how children's rights have been affected and what action they propose to take. This provides clear safeguards for Section 6. We will have a clear sense of how often it is being used and why, which allows us then to address incompatibilities. If we don't pass Amendment 51 now, or something similar at stage 3, then we simply will be living in ignorance as to how often the rights of children and young people we have incorporated into our laws are not being fully upheld. Amendment 51 has support from a range of organisations who have also suggested further improvements, which I welcome. Together has proposed that the Lord Advocate is notified, and the Scottish Human Rights Commission has asked for itself to be included too. And I would like to bring amendments at stage 3 to give effect to these requests. Together has also advocated a small technical refinement to ensure that public authorities or relevant bodies acting on behalf of children can bring proceedings seeking a declarator under the relevant sections of the 2024 Act. These improvements would enhance transparency, reduce the burden on children to initiate litigation, and ensure more effective oversight of the Section 6B in practice. I note the Cabinet Secretary has lodged Amendments 7 and 8 to address a similar concern. However, the intimation provision kicks in only where there are live legal proceedings, and I think we need something prior to that. Because if it's only where live legal proceedings are in place, it means where public authorities have identified potential incompatibilities, but where there are no court proceedings, we will again not be aware of this issue. As the Children's Commissioner notes, the Cabinet Secretary's 7 and 8 and my 51 are compatible with each other, and I urge the committee to support both. Part 2, as it stands, I think, makes a mockery of the whole process of incorporating the Convention into our law. I remain uncomfortable with the whole principle of Part 2, but the very least we can do is ensure that we keep a very close eye on how often it is used and then act to address any incompatibilities that arise. And that is what my amendment seeks to do. Thank you.
Thank you. Tess White to speak to Amendment 53 and other amendments in the group.
Thank you, Convener, Cabinet Secretary Committee. I speak on behalf of Stephen Kerr. So Amendment 53 introduces a duty on public authorities to publish a clear statement whenever they rely upon the exemption created by Section 2. This would require the authority to identify the statutory provision that compelled the Incompatible Act and to set out the reasons why no reasonable alternative existed. The intention behind this amendment is to ensure that reliance on the exemption is open, accountable and justified. It prevents situations where an exemption is applied without explanation or where a public authority quietly assumes it must act incompatibly without testing whether another route exists. This amendment ensures that the exemption is used only when necessary and that its use can be understood and examined by Parliament, by stakeholders and by the public. Amendment 54 complements this by placing a duty on ministers to review and report on the operation of the exemption within 3 years of its commencement. The committee heard during stage 1 that the government had difficulty articulating circumstances in which Section 2 would be needed. The explanatory material did not provide examples. The policy case was not fully set out. And it's against that background, it's only sensible that Parliament should revisit the question once the provision has been in force and is able to see whether the exemption has been used, how often and for what reasons. This review requirement helps ensure that Section 2 does not drift into becoming a broad or routine mechanism for avoiding compatibility duties. It gives Parliament the tools to assess whether the exemption remains proportionate and whether adjustments, tightening or even repeal might be appropriate in light of experience. It turns a theoretical exemption into a practical, monitored and evidence-based one. And finally, these amendments do not frustrate the government's policy intention. They assist it by ensuring that public authorities have clear expectations, and by protecting the credibility of the compatibility framework, they strengthen the overall legislative scheme and provide reassurance that the exemption will not be misapplied or misunderstood. So, Cabinet Secretary, you can see Stephen Kerr is passionate and views this as really important. So, based on what your response is, are you willing to consider meeting Stephen Kerr to discuss this in advance of stage 3? Thank you.
Thank you. Cabinet Secretary to speak to Amendment 7 and other amendments in the group.
Convener, just for the record, I'm always willing to meet with Mr Kerr. He has made no such approach to my office that I'm aware of, and I'm also willing to meet with Conservative members. I think I've met with every other party in advance of stage 2, but I'd be very happy to meet with him or other members who are around the table today ahead of stage 3. I think it's important we do that. Now, on all of the amendments in this group, they seek to respond to the evidence that was heard and submitted at stage 1, which called for greater transparency in situations where this exemption that we've been discussing has been introduced through the bill is relied upon. My amendments, as I think we've heard, 7 and 8, insert a new section 34A into the UNCRC Act, which is triggered at the point in proceedings when we would expect a public authority to have taken legal advice and to be reasonably confident in their view that the exemption applies. This means that when the question of whether the exemption applies arises in legal proceedings, there would be a clear point at which the notification must take place. Now, in those cases, the Lord Advocate, the Children's Commissioner and the Scottish Human Rights Commission should be notified unless they are already parties to the case. The Lord Advocate and the Commissioner bodies will then have the opportunity to intervene on that question. Now, this approach offers an effective safeguard that ensures that Scottish Government, the Children's Commissioner and the Scottish Human Rights Commission are aware of every case in which the exemption is relied upon in a court or in a tribunal. Now, crucially, because the duty arises when the exemption is raised in proceedings, there would be a clear objective trigger point. In my view, this provides for an effective and a workable route to gather greater transparency, and it also will allow the Government to identify and assess potential legislative incompatibilities. I also consider these to be the most appropriate bodies to whom a public notification should be made. Amendment 51, in the name of Maggie Chapman, would place a duty on public authorities to notify the Government and the Children's Commissioner where the public authority is of the view that an act or omission is not unlawful as a result of the exemptions in Section 6A or 6B. It also proposes a duty on Scottish ministers to report annually on those notifications, including about the impact on children and any action that ministers intend to take in response. Now, I have carefully considered what Ms Chapman is seeking to do here and to try to understand the rationale for how her amendment is framed. But it is important that public authorities have the space to deliberate about how to read and give effect to their legislative duties, compatibility and also whether the exemption may apply. A statutory duty of the type proposed in Amendment 51 risks inhibiting those deliberations because public authorities might fear legal challenge, both if they report and if they fail to report to the Scottish Government, when in their view the exemption should apply. It would also be difficult for a public authority to determine the precise point at which it was of the view that the exemption applies, and therefore for public authorities to be held to account for a failure to adhere to the notification duty. That lack of clarity risks creating further uncertainty, and it also raises questions about whether a legal duty would be meaningful in practice. We all have a responsibility to carefully consider the impact of placing further statutory duties on the public sector, whether doing so is proportionate to the perceived benefit and whether there's an alternative way of achieving the same goal. I'm happy to do so.
I thank the Cabinet Secretary for taking my intervention. I suppose I just have a question, given the point I made about the point at which any incompatibility issue is raised. If as with your amendments, it only happens when there are live proceedings, what options do you think are open to public bodies to raise issues of incompatibility without there having to be a live proceeding in place? Do you think that could happen informally? Do you think do you think there is any mechanism of doing that? Because I do take on board the point that you make of being concerned about having a statutory responsibility and the threat of legal action one way or another. I accept that that's a concern, but I do think there's something about preempting live decisions and live cases and how we could actually prevent stuff getting into proceedings.
So I would agree with the overall view of Ms Chapman, and of course it would be the government's view that we would want to avert legal proceedings. However, I am of the view, certainly the government is of the view, that a more proportionate approach could be delivered through Amendment 7, which does require the statutory notification at the point at which the public authority is seeking to use the exemption in court, as we've talked about. And also, I'd like to come on to talk about the Children's Rights Scheme, which was laid before the Parliament last month. I mentioned it in a previous group, but the scheme, the Children's Rights Scheme, commits the government to asking public authorities at least annually whether they have identified any legislation that they consider incompatible or whether they intend to rely on the exemption. So I think that answers Ms Chapman's point. But in addition, the statutory guidance for the UNCRC Act encourages public authorities to alert the government when they have concerns about potential incompatibilities. So I hope that that gives Ms Chapman some reassurance. And of course, as I think I set out in a previous group, we will be reviewing the impact of that next November, considering all the points that Ms Chapman has rightly raised in the space of today's debate. Now, Amendment 53, in the name of Mr Kerr, makes similar demands of public authorities, and the same concerns I have set out would also apply. And while I cannot support a statutory notification duty on public authorities, I believe the alternative that I brought forward is more proportionate and workable in practice. Turning to the aspects of Amendment 51 that would require Scottish ministers to publish a response to notifications, alongside Stephen Kerr's Amendment 54, which both speak to a theme of reporting publicly and updating Parliament, I can understand and I support aspects of what members are seeking to achieve here, but requiring ministers to collate and publish information on an annual basis, which is what Amendment 51 does, creates a risk that regular set timing of a government response duty could lead to the government being required to respond, even when we've got live disputes and litigation still underway, or taking a view on issues that are more appropriately resolved by the courts and tribunals. So it may also create expectations that the government should advise public authorities on how to interpret their statutory functions in a UNCRC compatible way, while authorities' own consideration is still underway. The government has no role in providing such legal advice. Stephen Kerr's Amendment 54 also attempts to create a review mechanism, but there are issues with including Section 6A within a statutory reporting requirement of this nature. Members will be aware of the sensitivities surrounding Section 6A, which simply restates the existing Section 6.4 in the UNCRC Act and was added following the Supreme Court judgment. This was subject to the careful analysis and scrutiny applied at reconsideration stage. And again, it would have been useful to understand Stephen Kerr's motivations for seeking to revisit these matters in this bill, but I gather he's now keen to meet with me, so we perhaps can have that discussion in advance of stage 3. I am sympathetic to much of what Mr Kerr has said and is trying to achieve here, but I'm not able to accept the amendments as they are currently drafted. However, I also acknowledge that in my response to the committee's Stage 1 report, I would commit to updating Parliament on the operation of Part 2 of the bill. So I would ask members not to press their respective amendments in this group to allow me to consider further what more we might offer in terms of reporting alongside Amendments 7 and 8 in this space. I consider that to be the right approach. My Amendment 7 creates a clear and appropriate trigger for notifications to be sent to the government, which gives effect to the first part of what Maggie Chapman's Amendment 51 is really seeking to achieve. If we can agree that my Amendment 7 and also 8, which is consequential and technical, then I can proceed to consider how and when ministers might update and report on the operation of the exemption. Convener, I therefore move my Amendment 7 and encourage members to support it and Amendment 8. Thank you. Paul O'Kane.
Thank you very much, Convener. I think there has been a degree of confusion and concern from Stage 1 and from the report of this committee, and indeed the wider debate around why this amendment to NCRC incorporation duties is being sought to fix a problem that the government is not aware perhaps exists at present. And I don't want to go over what colleagues have said, because I think it's been well laid out. But I do believe it's important that government and Parliament understand as soon as possible where and when potential conflicts between UNCRC duties and acts of the Parliament or acts of the Scottish Parliament occur. And I think through early understanding, then government and Parliament can step in and attempt to resolve the conflict if that is desirable or needed. And I think, turning to the amendments in the group, I think the Cabinet Secretary's amendment I think within that she has conceded perhaps the principle that there has to be a form of notification, and that needs to be made as soon as a situation becomes aware. So just following that debate there and that discussion, I do think there is room within this to further expand that notification point. I have sympathy with Maggie Chapman's intervention in terms of whether or not the amendment as drafted is perhaps too late in the process, because as Children's Commissioner had pointed out, we would require a child to have navigated the complexity of the legal system essentially and overcome quite a few barriers in proceedings before any notification would occur. So we know in reality that's probably a fairly unlikely inflection point, if you like, for the notification to happen. So I'm really open to various options for an early reporting mechanism. I'm yet as unconvinced as to what the right stage in the process should be and what the right amendment would be in order to put that onto the bill. But I appreciate what the Cabinet Secretary has said previously, but I just wonder, can she just confirm that she is open to looking at those intervention points, and is she willing to work on, I suppose, on a cross-party basis, if that's appropriate, in advance of stage 3 to try and find something? I appreciate she's going to just probably repeat what's been said, but I just think it would be useful for the record. If she wants to intervene, that is, sorry, convener. I appreciate it's not an evidence session.
Happy to intervene, convener, to provide clarity to committee. I'm very keen to work on a cross-party basis on this, to the points that Mr O'Kane has raised. I'm
very grateful to Cabinet Secretary, and I think on that basis I am minded to support the government amendment because it is a starting point, I think, for the work that is yet to be done, and then to allow for further discussions in advance of stage 3 with colleagues from across the committee. Thank you.
Maggie Chapman to wind up. Press or withdraw Amendment 51.
Thanks very much, convener, and thank you to everybody for this groupings debate. I think it's been helpful. I think there are still some issues that we can explore further at stage 3 or before stage 3. I'm not sure I agree with the Cabinet Secretary's judgment of where of the potential consequences of my Amendment 51, but I think there's room for manoeuvre, hopefully, in the coming weeks. And with that, I will withdraw my Amendment 51. Thank you.
Maggie Chapman seeks to withdraw Amendment 51. Does any member object to the amendment being withdrawn? No, there are no objections, so the amendment is withdrawn. I call Amendment 52 in the name of Stephen Kerr, already debated with Amendment 45. Test White to move or not move?
Not moved.
Not moved. I call Amendment 53 in the name of Stephen Kerr, already debated with Amendment 51. Test White to move or not move?
Amendment 53, I move.
Thank you. The question is that Amendment 53 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 53? Those against? Any abstentions? The result of the division on Amendment 53 is 2 for, 4 against and 1 abstention. No? Okay. It's 2 for, 3 against and 2 abstentions. The amendment is therefore disagreed to. I call Amendment 54 in the name of Stephen Kerr, already debated with Amendment 51. Test White to move or not move?
Moved.
The question is that Amendment 54 be agreed to. Are we all agreed? We are not agreed. There will be a division. Those in favour of Amendment 54? Those against? And are there any abstentions? The result of the division on Amendment 54 is 2 for, 4 against and 1 abstention. The amendment is therefore disagreed to. I call Amendment 7 in the name of the Cabinet Secretary, already debated with Amendment 51. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 7 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 7? Those against? And any abstentions? The result of the division on Amendment 7 is 5 for, 2 against and no abstentions. The amendment is therefore agreed. I call Amendment 8 in the name of the Cabinet Secretary, already debated with Amendment 51. Cabinet Secretary to move formally.
Formally moved.
The question is that Amendment 8 be agreed to. Are we all agreed? Yes. We are not agreed. There will be a division. Those in favour of Amendment 8? Those against? Those against? Any abstentions? The result of the division on Amendment 8 is 5 for, 2 against and no abstentions. The amendment is therefore agreed to. Okay, the question is that Section 2 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 55 in the name of Tess White, grouped with Amendment 56. Tess White to move Amendment 55 and speak to both amendments in the group.
Moved, Convener. Cabinet Secretary, Convener and Committee, these amendments are about making sure we properly understand the impact of this bill before it comes into force, rather than dealing with problems after the fact. And my colleague Paul O'Kane has actually made the reference to the fact that we've got just over 3 months to go, and it almost feels that this bill is being rushed through. And it isn't a simple bill. At stage 1, we heard concerns about workload, resources and the effect on relationships between schools, parents and pupils. These amendments ensure those concerns are properly considered in advance. And I have raised earlier the point that only 3 education authorities were consulted. I just would like to stress that. It shocked me. Amendment 55 requires the Scottish ministers to carry out and publish a pre-commencement impact assessment on the likely effects of the bill. This assessment must look specifically at the impact on families, parents, children, teaching staff and support staff. And that matters because this bill introduces new duties and new processes for schools, and those changes will affect real people in real settings. Amendment 56 makes sure that the impact assessment is considered by a parliamentary committee with responsibility for education before the Act is commenced. This gives Parliament an opportunity to scrutinise the findings and ensure any risks or pressures have been properly thought through. Thank you.
Thank you. Paul O'Kane.
Thank you, Convener. I don't have too much to say on these amendments, other than I understand the intent, I suppose, behind it, but I am concerned that in compelling a future committee of the Parliament through primary legislation, is that is probably not an appropriate use of legislation, and to my mind, is perhaps not a sensible way to legislate, and indeed not prudent to. Trying to bind, I suppose, successors of any committee of the Parliament. So I think just worth to put that on record that whilst I understand the intent, I am concerned about the process.
Okay, thank you. Cabinet Secretary.
Convener, Tess White's amendments 55 and 56, as we have heard, propose to introduce a statutory duty on ministers to carry out a pre-commencement impact assessment and link commencement of the Act to that new duty. Amendment 55 would require ministers to undertake and publish a formal impact assessment, which would then have to be scrutinised by the Parliament's Education Committee, as we have heard, before the substantive provisions of the Act come into effect. I note in passing that Tess White does not anticipate a role for this committee in that process. Amendment 56 would bring the section created by Amendment 55 into effect on the day after royal assent. However, Amendments 55 and 56 effectively create a duplicate requirement. The Government has already published a comprehensive impact assessment following the Bill's introduction at Stage 1, including a Child's Rights and Wellbeing Impact Assessment, an Equality Impact Assessment, an Islands Communities Impact Assessment and a Fairer Scotland Duty Impact Assessment. Those have been shared with members of this committee who have had the opportunity to consider, and that opportunity remains available in terms of scrutinising those assessments and seeking any further clarity from Government on any matter that any of them raises accordingly. Now, Amendments 55 and 56 would frustrate and delay implementation of the Bill's measures by making commencement contingent on completing and a further impact assessment, and this being considered by a relevant parliamentary committee. They introduce an unnecessary procedural hurdle and take up the valuable time and resource of this Parliament and its members. They would also impose additional costs and administrative burden on the Government. Fulfilling the duty would divert resources from implementation and developing associated guidance that we have discussed today. In short, adding another statutory impact assessment would provide no added value, and for those reasons I cannot support Amendments 55 and 56, and I would hope that Tess White will not press her amendments. If she does, I would encourage members to vote against them.
Tess White, to wind up, press or withdraw Amendment 55.
Thank you, Convener. I hear what the Cabinet Secretary says, and I hear the words that she says about a necessary hurdle. But the concern that was raised in the Stage 1 report, and I quote paragraph 151, very serious concerns have been presented to this committee about both Parts 1 and Part 2 of the bill. And in paragraph 154, that support is, however, still predicated on very significant amendments being made to the bill, which I've not really heard a lot of today. So I suppose what it's doing is forcing a proper consultation and impact assessment. And I hear what my colleague Paul O'Kane says about placing a duty on the Education Committee, and I understand that. But these two amendments are about good lawmaking, and they help ensure that the bill is implemented in a way that is proportionate, workable and informed by evidence. So therefore, I will be pressing these two amendments. Thank you.
The question is that Amendment 55 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 55? Those against? Any abstentions? The result of the division on Amendment 55 is 2-4, 5 against, no abstentions. The amendment is therefore disagreed to. The question is that Section 3 be agreed to. Are we all agreed? I call Amendment 56 in the name of Tess White, already debated with Amendment 55. Tess White, to move or not move?
Moved, Convener.
The question is that Amendment 56 be agreed to. Are we all agreed? No. We are not agreed. There will be a division. Those in favour of Amendment 56? Those against? And any abstentions? The result of the division on Amendment 56 is 2-4, 5 against and 0 abstentions. The amendment is therefore disagreed to. I call Amendment 57 in the name of Tess White, already debated with Amendment 36. Tess White, to move or not move?
Not moved.
I call Amendment 58 in the name of Tess White, already debated with Amendment 36. Tess White, to move or not move?
Not moved.
The question is that Section 4 be agreed to. Are we all agreed? Yes. The question is that Section 5 be agreed to. Are we all agreed? Yes. I call Amendment 19 in the name of Maggie Chapman, already debated with Amendment 9. Maggie Chapman, to move or not move?
I've never amended a title before. Moved.
The question is that Amendment 19 be agreed to. Are we all agreed?
Yes.
We are not agreed. There will be a division. Those in favour of Amendment 19? Those against? And any abstentions? The result of the division on Amendment 19 is 4-4, 3 against and 0 abstentions. The amendment is therefore agreed to. The question is that the long title be agreed to. Are we all agreed? Yes. That ends stage 2 consideration of the bill. That concludes today's meeting and our meetings for the year, and I thank you all for your contributions this morning and over the course of this year. I hope that you can all have a good break over the festive period, and I look forward to seeing you back here on the 13th of January when we will return to consider the Scottish Government's response to our public sector equality duty report. I now close the meeting. Thank you.